Hearing in the appeals of the estate of Dame Bernice Lake QC deceased against Attorney General of Anguilla.
Good morning, my lords.
Mr. Clayton.
My lords, I appear together with the attorney, Mr. Dwight Horford and Richard Moule, so my learned friend, Mr. Rowe, Queen's Counsel, appears with Kendrickson Kentish and Careth Kentish.
I'm so sorry, Mr. Clayton. I think I've got the wrong laptop.
Yeah.
I say that with full sympathy for our team. They all look just the same.
Yes, well, can I say, having lifted an incredibly heavy set of papers, because I don't use laptops, it is just so much heavier doing it that way. See fit.
That looks much better.
My lord, as my lords will know, and my lady, forgive me, both these appeals arise out of a compulsory purchase of land on the 28th of November 2003 by the Government of Anguilla pursuant to Section 2 of the Land Acquisition Act for the purpose of extending the airport, which is now the Clayton J. Lloyd International Airport. The land in question was formerly owned by a well-known Caribbean lawyer, Dame Bernice Lake Queen's Counsel, and following her death, the estate pursued the compensation case. There are 4 areas of land which are of importance for my lords to note. There are 10 acres which were the land acquired by by the government. 16 acres were acquired and then returned, and compensation is sought in respect of their temporary possession. There is a parcel of 100 acres, or thereabouts, which was owned by the estate from which the 2 earlier parcels were acquired. And there was the parcel 126, which is adjacent on the eastern side of parcel 100, which was owned by members of the family and which together with parcel 100 comprised the forest estate. And together was the fact that those 2 parcels were together which led to the debate about amalgamation and fusion, which was rejected by both the board and by the Court of
Yes,
Appeal.
Mr. Clayton, I don't know about you, but it would help me at any rate, and I think some of my colleagues, if we could all be working off the best plan.
Yeah, can I take
which locates all this both in terms of the airport and the sea.
We have the best document is which I was about to take you to is a photograph which is appended. My lords will have noted, and lady will have noted that we put a coloured copy of the and if you turn.
I'm sorry, I'm not sure I've got a coloured copy.
It's in the core bundle. In fact, but we put a coloured copy in. It's also got an MS number. It's MS. Sorry, it begins at. Forgive me.
323.
MS 4322, which is the report. So you should have it in the electronic bundle.
4322 is a document bearing your signature.
I think it's the next page, Mark.
Yes, you've got the usual problem being 1 page out, Mr.
Oh.
But the plan, which I think you're hoping to take us to, is at page 4328.
4328, yes. So if we turn that up for a moment.
Okay.
Or perhaps put it sideways, at least I will. On your left, you'll see the 2003 airport. And then you'll see there's an extension, and there's a 10-acre parcel, which is, I think, is in pink and blue. And then there's the 16-acre parcel revested because it was unnecessary for the development. And the 100-acre piece of land appears below those 2 parcels. And then to your east, to the right, is the additional parcel of land which comprises the total of 361.
But that's not marked.
No.
No, that's not marked, and we don't have it, because in the end, what happened, as you may recall, is the family argued before the board that you had to look at the 361 parcel. The board rejected that,
Yes.
and although it was cross-appealed, it was also rejected by the
And this
board.
plan is north up, is it?
Yes, well, holding it this way, yes.
Oh,
I think that's
how I
right.
put it.
Yeah.
The beach is at the southern end.
Yes.
Right.
Hello, just for completeness, I think we do have a photograph that shows the other bit as well, the 126. That's at 4353, I think.
4353. Yes, that's very helpful, actually. Yes, you'll see that. That takes us to the coast, I think.
And that includes a lot of coast, but not much more beach, because it's all fairly rugged.
That's correct.
Or at least it was that day when the wind was from the east.
Yes. Well, I hope that makes it a little bit clearer in terms of.
That says parcel 136, parcel 36, where I thought we were talking about parcel 126.
I think that 126 is the parcel immediately below. In other words, adjacent to parcel 100.
Yes, I see.
To the right on the map. Copy of the photo.
Sorry, I don't follow. Parcel 36 appears to be bounded by a blue line, and it includes a boundary with parcel 100.
Yes, but I was talking about the forest estate is parcel 126, which isn't marked, but as I understand it, is below parcel 36. It's the unmarked bit.
Well, parcel 36 seems to be the whole area, apart
I'm
from
so sorry, you're
parcel
right.
35 that
That's
is
my
carved
fault.
out.
Well, I think, as I understand it, it's called throughout the proceedings as parcel 126. But my Lord Sales is right. It's actually, it's a whole portion. And the important part is you can see that it's larger and it's adjacent to parcel 100. Now, if I could turn.
Just going back to 4328,
Yes.
the strip of land that's above the 10 acres and the 16 acres, that's also part of parcel 100, and is that acreage included in the 100 acres that you were referring to?
It is included, yes.
And it's 110, I think, in total. I think it's 100, forgive me for speaking over, but in case it's helpful, at parcel 100, as I understand it, and I'll be corrected, I'm sure, if I'm wrong, by those who know the case very well, but parcel 100 is the thing which is outlined in yellow on 4328, is 110 acres in total, out of which
10.
And it's 10.
initially 26 acres in total were taken, and then in 2008, 16 of those 26 were handed back, as it were.
A bit of the trapezium on the top is cut off from the rest.
That's right, but it's originally it's all part of the same
I understand.
parcel 100. Yeah.
And yeah, but when the 16 is restored, essentially it's linked back to.
Yes, it becomes
other bits
it becomes
of
part of parcel 100 again, and its only relevance then is whether there's a claim for the fact that it was for a period of time in the government's possession.
Thank you very much. Both appeals, as my lords will know, arise in relation to a decision of the Eastern Caribbean Court of Appeal dated the 11th of December 2018, which in part reversed the Board of Assessment's decision dated the 11th of March of 2018. It's important to appreciate that at the outset, the estate claimed compensation of 53.79 million US dollars. That figure did not commend itself to the board, who awarded the estate compensation totaling 1.26 million and held that the second respondent was not entitled to compensation. It had no land taken from it. What in fact happened next was that the estate in the Court of Appeal effectively reversed the board, principally on fact, and awarded compensation on the sum of 19.15 million US dollars, but affirmed the position in respect of the second respondent. We would, with respect, suggest there are at least 4 critical errors in the Court of Appeal's reasoning in reversing the board. First, as an issue of statutory construction, and that's Section 18 of the Land Acquisition Act, the Anguilla Land Acquisition Act, the focus has to be on the land acquired. Secondly, the Court of Appeal held, reversing the board, that the highest and best use of the land to be valued was for high-end tourism, when in fact there was no evidence at all to support the assertions of Mr. Glean, the expert on whom the estate relied.
I thought it was for high-end tourism stroke residential use, not purely high-end tourism.
Well, it's principally high-end tourism. The reason why I make a distinction is because the report of Mr. Childs was that there was basically some residential use around the airport, but that was not at the top end of the market.
But I thought very specifically the Court of Appeal said, well, there's some evidence of valuation for residential lands, some for coastal lands, and then they produced an amalgam of the two.
That's true, but that's right. But in terms of what, my lords, I was about to turn to that, but in fact what actually the Court of Appeal did, which is the third error, was to basically rely on, well, combine the two errors, to combine the two valuations, which was the valuation given by Charles and the valuation given by Mr. Glean. And that was a very odd thing to do, and it was particularly odd because the Court of Appeal were not concerned averaging like with like. Mr. Childs was giving a figure for 10 acres. Mr. Glean was giving a figure in his report which was for 361 acres. And in fact, the Court of Appeal confirmed the board was correct on fact in saying the relevant figure was 110 acres. So it was a very odd thing to combine amalgamate those two values. But that's particularly odd because there's a fourth error, which is there is no evidence or reason to suppose that the value of the acres was identical for each acre, which is effectively the assumption made in amalgamating the two, that 361 were equivalent to 110. And it all depends on the bit of land you're talking about.
Yes, and that assumption is quite separate and distinct from a before and after valuation.
Yeah.
Yes.
Well, is that right? I mean, if you buy a piece of land, you tend to pay a price per acre, which is in effect an average of the high and low values of that land, isn't it? If I was selling a plot of 100 acres, some of which was more desirable than others, I wouldn't charge a separate price for different acreage.
No, with respect, my lady, the point is this, is that the figure that Mr. Glean worked from was 361, to take a simple example. That included coastal land.
Yes.
The figure of 126, so the land did not contain any coastal land. And so it all depends, the value will depend upon what area of land you're talking about.
Yes, okay.
Can I next turn to the Land Acquisition Act?
Just before we leave the plans,
Yeah.
it looks as if, looking at the plan on page, well, on both plans, but particularly the plan on page 4353, that there's a public right-of-way running, broadly speaking, east-west, just south of the bottom of Parcel 100, and that the beach itself is not part of that parcel. Have I, and one gets no, I think, no different picture from the plan on page 4328, because although the public right-of-way is not highlighted, you can actually see it as a photograph going from west to east and ending up at that red-roofed house, which is not on plot on Parcel 100.
So my lord is looking at Parcel 100? Or
Well, I'm looking at the bottom of Parcel 100
Yeah.
on both plans and noting that it doesn't appear to include the beach.
I think that's right. But the point I was making in response to Lady Rose was that the coastal area marked in the larger plot.
Oh, yes.
So that's why you can't just say, well, the acreage.
Mine was a completely different question.
Yeah.
I just wanted to make sure I correctly read the photographs.
I think that's correct, as I understand it. And no doubt I'll be corrected if I'm wrong.
No, I'm sorry, it was an interruption.
No, not at all. Not at all. Can I next turn to the legal framework? Which is the Land Acquisition Act, which you'll pick up which is actually in the authorities bundle, but you'll pick up at page MS 4526. That's where it starts. And I want to begin, if I may, at MS 4532. If you have that, you'll see that Section 10 of the Act states that all questions and claims relating to compensation are submitted to the Board of Assessment. Section 11 states that a board of assessment will be appointed, and it's quite, if I may put it this way, the composition of the board is significant. It contains a High Court judge, and then, as we refer to in the case, a member appointed by the governor, a member appointed by the owner, and they are all distinguished people. We've set that out in the case. And of course, they're an expert body, and in our respectful submission, their conclusions are to be accorded some degree of respect as experts.
Why should one suppose that, leaving aside the judge of the High Court, either of the other two members would be experts?
Well, if I can...
I mean, they may have been.
We've dealt with it in the case. Sorry. Can you just give me a minute? We discuss it.
The member nominated by the state was whom?
Can you just give me a moment?
Yes.
I'm so sorry. That's 4306, paragraph 11. So we have the High Court, if you have that, the High Court judge. The Attorney General's appointee was Elizabeth Stair, a fellow of the Institute of Chartered Surveyors, a chartered valuation surveyor, attorney at law at Jamaica, and for many years a chief executive officer of the National Land Agency in Jamaica. So we would respectfully say someone of some expertise. The respondents appointed a Mr. Clarvis Joseph, a prominent businessman and a former president of the Antigua Chamber of Commerce, and for those who were interested, we point out he was also the Vice President of the West Indian Cricket Board. But in any event...
my question, I mean, we're looking at statutory construction at the moment rather than the actual constitution.
Yes, we are.
And my question is, why should it be taken from the statute that the board would be any more specialist in this particular, quite specialist field than the court generally would be, than the High Court generally would be?
Well, because the reason we would submit that the purpose of Section 11, and indeed the way it was applied, was to ensure that people of requisite expertise were engaged in the fact-finding exercise.
But Section 11 doesn't seem to say anything about that.
No, I accept that's open.
The parties could pick anyone they liked if you just look at the text of...
Well, that's perhaps why I drew your attention to the actual composition. But I accept the force of the point. It's not Section 11 itself which specifies that they have a high degree of expertise. I accept that.
My Lord, I'm sorry, just before my friend leaves this issue, just on a point of fact, the High Court judge in this instance, Your Lordship may have picked this up from the papers, wasn't in fact a High Court judge until he was appointed as such for the purpose of making him eligible to sit as the chairman of the Board of Assessment. I think that's common ground.
He was appointed a judge?
There was quite a long process of appointment. Originally, a High Court judge was appointed. She then was appointed to the Court of Appeal, thereby becoming ineligible. So it was thought, at any rate, to sit as the chairman of the board, chairwoman of the board. So at that point, apparently what was done was that Sir Clare Roberts QC was appointed a High Court judge, but never in fact sat as a High Court judge.
Well, he did,
other than in the capacity of a High Court judge appointed to chair this board.
Okay, well, if we have any points to make about that, I'll come back to it. The procedure before the judge, the inquiry is governed by Section 14. The award of the board is covered by Section 16. And then subsection 16.3, an appeal will lie against the decision of the board to the Court of Appeal. It's Section 18, which in our submission is the principal focus. And Section 18.1 reads that the rules set out in this section shall...
I'm so sorry, just on the technical point, Section 16.3 just says an appeal shall lie against decision of the board to the Court of Appeal. So it's not limited to an appeal on an issue of law, is that right?
It's not, but it was accepted before the Court of Appeal that it was subject to the usual limitations on the Court of Appeal's ability to interfere on findings of fact, which they have to effectively be irrational findings of fact. And that's the position in Anguilla as it is in the United Kingdom.
Yes, thank you.
Thank you very much. So, sorry, forgive me, I was looking at Section 18, and I was reading 18, subsection 1. The rules set out shall apply for the assessment and award of compensation for the compulsory acquisition of land. And then the point I want to make, and I'll go through this in respect of every time land is mentioned, including subsection 2, the land which is being referred to is for the compulsory acquisition of land. In other words, that the land that is valued in section 2, subsection 2, is for that land which is acquired. And I say that because the phrase land appears in subsection 2.
Is this form as amended as a result of the first Lake case, or is it its original form?
This is the original form.
Thank you.
Sorry. Where am I going to find that?
I mean, we've been
I
given
think the deeming provision was taken out, wasn't it? The deeming for agriculture.
We've been given two amendments, I think. Subsection 2 the words "for the purpose of being put to the same use to which land was being put at the material time" have been taken out.
Yeah.
And I think in subsection 4, paragraph D,
Yes.
the words "the date 12 months prior to" have been removed.
With respect, we would agree. In fact, that appears in our case at paragraphs 16 and 17, MS 4307, 4308.
Are there any other changes?
Not that are which we are aware. Can I just? I don't think the changes affect the burden of the point I was about to make, which was that my lords and lady will see that the phrase "the land" appears in subsection 3 in the first sentence and the second. Sorry, the first line and the second line appears in 4, in the first word in subsection A. In 5, the first line, the suitability or adaptability of the land is the purpose for which the land could be applied. 6, the value of the land. 7, the land is but for the compulsory acquisition, which makes it even clearer. We are here concerned with the land which is being acquired. And then 8, no allowance shall be made of the acquisition being compulsory. B, again, expressly refers to the land as being the land acquired. E, so this is subsection E of 8, the value of the land acquired. And it's F, the land being acquired. So the short point is, as a matter of construction, for the purposes of Anguilla, the value of the land in 18.2 is the land which has been acquired. I want to make a separate, but in our submission, a very important point about subsection 18.2, which, if I can read it out first, the land in its condition at the time, which might be expected to realize if sold at the time in an open market by a willing seller. And the key point to appreciate about that is it's about a hypothetical seller. It's not the actual seller. And in fact, it might be of assistance to look at one of the submissions made before the Court of Appeal, where this is made, spelled out very clearly. If you could turn, please, to, forgive me, it's 2360.
Sorry, is this in the judgment of the Court of Appeal?
No, this is actually in a supplementary skeleton. It's one of the cases, one of the submissions made to the Court of Appeal. And it just is helpful because it spells out perfectly clearly that we're concerned here with a hypothetical sale. I don't know if you have 2362?
Yes.
2362.
Yes, thank you. Paragraph 7 makes a number of points about section 18.2, which I won't burden you with. But if I could look at the phrase, if sold at the time in the open market by a willing seller, which was the point that I was just talking about, this phrase is fundamental to the valuation exercise. It provides the objective method by which the value of the land compulsory purchase is to be assessed. It derives from legislation first enacted in the United Kingdom in 1919 and subsequently adopted in many other jurisdictions. The words "if sold" refers, of course, to the land, in this case the 10 acres. That's the submission I've already made. At that time means at the material time. The phrase as a whole requires an estimate to be made if the buyer in the open market would have been willing to pay for the 10 acres. It is well settled that a willing seller is entirely hypothetical and not the actual seller. Thus, for example, in Troquet Properties, Lord Justice McGaw, referring to those words in the English legislation, says, "The willing seller is a hypothetical character. There is no justification for attaching to him so as to increase or reduce the assessment of the land any special characteristics. He is assumed to be selling at the best price he could reasonably get in the open market. the concept of a willing seller as a hypothetical anonymous person has been explained in many cases and endorsed by the Court of Appeal in the Winwood property case. Now, the point about it being a hypothetical seller has two implications, which are important in this case. The first is the aspirations of the estate about the value of the land are legally irrelevant. And that's the high point of the case, that it can be made against the Attorney General. They have aspirations. I'll deal with the aspirations in more detail later. But the second point, which is equally important, is because it's a hypothetical seller, there has to be evidence of the value that the hypothetical seller would buy for. And in this case, Mr. Glean, with great respect, produced no evidence whatsoever to justify the value he attributed. None.
But sometimes it's a very hypothetical type of sale. I mean, it might be of some apparently odd-shaped strip of land which no person in the real world would either sell or buy, or in particular buy.
Yes. I'll come.
I'm just looking at your point about evidence. I mean, the evidence may, and in many cases, will fall short of being precisely analogous, won't it?
I accept that. Can I make two separate points in response? The first is, with respect, the evidence from Mr. Childs, the attorney's expert, was precisely that before the board that my lord just suggested. He said, well, you might need to look at the total parcel of land if you're dealing with, say, a strip of land which is valueless in its own, as itself. That's the first, so I entirely accept that, but that's an exception rather than the rule, if I can put it like that. But what is really important, and is, in our submission, a significant failure by the state, is the failure to adduce expert evidence which gives a value. It's not good enough to say, well, we felt on the basis of what we knew that it might turn into high tourism. That's not good enough.
But when you're talking about the hypothetical seller, do you say that it follows from that one of the characteristics of the actual seller that you have to disregard is the fact that they own a large piece of contiguous land which goes down to the coast?
No, I'm not saying that. What I am saying, though, is that what you can't do is rely on the aspirations of the actual seller in substitution for the evidence which the valuer has to adduce. That's the point.
Well, in a sense, the aspirations reflected in the price for which this real owner would be prepared to sell.
Well, they may or they may not be. I mean,
I understand. But that's your submission. That one takes a notional seller.
Yes.
And considers, subject to my lady's point, what would be the market price for the land.
Yeah. And to do that, I mean, I will come to the board's material. Sorry. I'll come to the board's approach in due course. But the short point I'm trying to make is that in order to advance a case on behalf of the hypothetical seller, one has to have valuation evidence about how that would be valued. And here, that evidence was simply not put before the board. And you just can't rely on what the seller says he thinks it might be worth. That's the simple point. But it's important in the context of this case, because that is a serious vice on behalf that's made in relation to the seller. So, moving through, the two principal areas, as we understand it, in relation to the attorney's appeal, is whether the board was correct in saying that the value was as a standalone, the 10 acres was a standalone value, because the case made on behalf of the estate was that the value of a larger parcel must be ascertained in order to ascertain the value of the unit taken. That, for your note, appears in MS 1913, paragraph 71 of the board's decision. That's the way they encapsulate the case. Now, our point, and just so that this is clear, is that we have no difficulty with the concept that in appropriate cases you would value the land acquired by reference to a larger parcel. But that is provided, and always provided, that the appropriate valuation evidence is adduced. It's not, it depends on the evidence, in short. And in this case, no evidence that persuaded the board was adduced, and the approach that the Court of Appeal took with respect was, again, not based on evidence.
But as a matter of principle, why is that right? If you're looking at the notional sale by a willing seller of the particular parcel of land that's acquired, why, as a matter of principle, do you in some circumstances take into account the fact it's taken from a larger parcel?
Well, if, for example, it were the case, say, well, if this case exemplified, had there been proper evidence that this was all going to be developed for the purposes for which the estate contended, then a higher value would be attributable, which was the very approach that they contended.
But why? I thought that Section 18 requires, as you were emphasising to us, that one assumes that the particular parcel is being sold separately.
Yeah.
So why doesn't one look at it as a separate parcel and say, well, what value does it have as a separate parcel? Why is that exercise affected at all by the value it might have as part of a bigger parcel, because ex hypothesi that's being broken up? And that's just focusing on the land. I can see there may be issues of injurious affection in relation to retained land, but as I understand your submission at the moment, we're just focusing on valuation of the parcel itself.
Your Lordship, I think to be my Lord's approach is actually the right one.
Well, it's important because, as I understand it, the case that's put against you is that you have to factor in the nature of the use to which the plot is going to be put as a whole in valuing this particular piece of land, this particular 10-acre piece of land which is sold.
No, that's not. That's the way it's put against us. Yes, I accept that.
But as a matter of principle, how do we decide which of those is the correct answer?
Well, because the starting point, as my Lord Sales just indicated, is you look at the land acquired, and it's only in
Well, that was really behind my question about whether you have to take into account the fact that they own the larger parcel, because one can see that if you own the land going down to the coast and somebody came to the owner and said, oh, well, I just want to buy this little 10 acres to build some local residential housing and I offer you $50,000 per acre for it, the owner might say no, because I've got plans and hopes that actually that's going to form part of a big development and we'll get a lot more for it. Yeah. But I thought that kind of aspiration, even if it was more than an aspiration in terms of how likely it was to happen, was something you had to ignore, because you did just have to look at the value as if the person was willing to sell the 10 acres for the value of that 10 acres, ignoring the fact that it was part of a larger parcel which they might sell as a piece for a higher value per acre.
So can you just give me a moment? My lady is, with respect, agree. I think, I'm sorry, I perhaps have confused the issue by trying to set out the position more.
I mean, I understand your point. Whatever value you're putting forward, you have to give evidence for it. It's not just because it's a hypothetical seller, it's not just what the aspirations of the seller are. But I think that's a different point from what they plan to do with the 10 acres itself.
And isn't it important that we get the conceptual picture right, because that's going to govern what is relevant evidence to determine the relevant comparables and hence the objective value of the land.
With respect, I would entirely agree. That's why I began by looking at Section 18 and what its implications are. I'm sorry if I've delayed us slightly by throwing some. Perhaps it might be easier if I let my friend advance his own case.
Yes. We are at some stage going to look at some authority on this question, presumably on similarly worded legislation.
Yeah, we will look at some English cases which bear on the point.
When you do, we've been doing a little bit of homework. You may want to address us on a case called Ramac Holdings Limited in Kent County Council, which isn't, I think, in the bundle, but I can see your juniors.
It is in the bundle, and in fact...
Did you say it is in the bundle?
It is in the bundle, and it was put before the Court of Appeal.
It's in the record.
Oh, so I'm so sorry, it's in the record.
Maybe in the record, but it's not in the bundle.
No, that's quite right, it's in the record.
Well, okay, in that case, I don't need to...
Just for our notes, where in the record is it? Because we hadn't spotted it.
No.
MS 2014.
Thank you.
And it was one of the authorities relied on before the Court of Appeal.
Okay.
The skeleton reference is MS 2241.
So that was the attorney's skeleton argument in the Court of Appeal, is that right?
Yes.
Could you give those page numbers again?
I'm so sorry, yes. Certainly, they are...
2014 for the case. Oh, really?
And then the reference for the case is MS 2014, and the reference to the skeleton of the attorney is 2241.
2014.
Is the first one right? The first reference looks like the middle of something else.
I'm not sure.
It is.
2014 doesn't look right to me.
No.
The second one is right.
I'm going to just let someone who's got a computer just double check the reference. I'm sorry.
Anyway, we have had copies made if it's of any assistance.
Which it may
It's
be.
2104. 2105. My friend's notes just got back to front.
Yeah.
Yes, good.
Okay.
Yep.
Just moving on to a slightly different point, we'd also draw attention to the fact that the emphasis placed by the estate on the larger parcel of land appears to be derived from by his expert, from something called the Dictionary of Real Estate Appraisal, published by a US-based appraisal institute. It's not a valuation, a conventional source of valuation evidence.
Sorry, when you say the emphasis by the estate on the larger parcel comes from that, which larger parcel are you now talking about?
It was the only evidence before the board and the Court of Appeal was the
Inclusive of parcel 126.
Precisely.
Right.
So whenever I refer to the larger parcel, the evidence that was given in respect of that, or the expert report that was given in respect of that, was always to the larger parcel.
And in that report, that there wasn't put forward alternative bases. Well, if I'm wrong, that you look at 100 and 126, and you just look at 100, then this, and if I'm wrong on that, then if you just look at the 10 acres, then my view is that it nailed its colours to the...
Firmly to the mast.
Yes.
Thank you.
And may I ask this? You referred us to page 2362 of the electronic record, and in particular, the decision of Lord Justice McGaw in the Troquet property case.
Yes.
I don't think we have that in our bundle. Is that something that you're going to be taking us to?
My Lord, am I able to help on that? If your lordships have I hope they reach the board a note that we put in on the 3rd of May. Certainly, the receipt was acknowledged by the registry, and we were told it was going to be put before the board.
Let us check.
It's called Estates Note Concerning the Attorney General's Appeal. Something that we wrote in the light of the fact that new counsel had come on board and wanted to put it in his own words to some extent.
I don't think.
Well,
It's the Word
You
document.
should look at that.
I'm just checking.
No.
and I mentioned at this juncture because the Troquet case is annexed to that note.
Right.
Yeah, it doesn't seem to reach
No,
there.
it hasn't certainly got onto our
Not in our.
relevant drive. And I don't recall seeing it in an incoming email.
It's a 10-page note with some documents annexed to it,
Well, we'll make sure we get.
and it's on page 12 of the PDF once you get to it, the Troquet case.
Thank you very much.
And what was
Anticipated my question.
what was the title of the note, Mr. Rose? Sorry, just so
It's called Estates Note Concerning the Attorney General's Appeal.
Thank you.
Thank you. We'll make sure we get sent it.
Right.
Right.
Mr. Clayton, you've had that note, presumably.
Yes, I do. And I've confirmed that with my friend. Another point we want to make is that there is a certain tension in the way the Court of Appeal dealt with the factual finding made by the board in relation to the parcel of land, the larger parcel, where it declined to upset that decision on the basis there was ample evidence before the board. That's the basis of that holding is at MS 2499, paragraph 16 of the Court of Appeal judgment. But oddly, in respect of other issues of fact, the Court of Appeal declined to take the very same approach, and we draw attention to that oddity.
So, which paragraph are you referring to on page 2499?
16. 2499.
I mean, it was rather more than that, because one of the reasons that the Court of Appeal, as I understand it, gave for rejecting the standalone approach was an apparent inconsistency between the Board of Assessment having dealt with this question of whether it was Parcel 100 by itself or Parcel 100 plus Parcel 126, and then adopting a standalone basis. Because if you, of course, adopt a standalone basis, then it doesn't matter whether it's part of 1, 2, 3, 4 or more parcels. It's not going to affect the value. So that was, that troubled them.
That's right, but what ultimately the Court of Appeal did was to reject the standalone basis.
Yes.
That's the point I'm making, is it rejected the standalone basis on the basis that the findings of the board which justified it were reversible, and which is only open to the Court of Appeal if they were irrational findings, which with respect they weren't. That's the point I'm making.
Yeah.
Well, irrational or made on the basis of a wrong approach to the principle to be applied.
Yeah.
So I'd have thought it's not so much irrational as the Court of Appeal saying it's wrong in principle to apply a standalone basis in the circumstances of this case.
Again, I'm happy to.
All right.
It's also worth noting that in dealing with the grounds of appeal, the Court of Appeal found it difficult to formulate the appeal issues themselves. That's at MS 2496, paragraph 10. Just give me a moment. So sorry. Sorry.
I mean, in a sense, so what? I mean, they did formulate comprehensible grounds of appeal, and I don't think anyone said that they misunderstood what the appeal was about, did they?
No, but I was going to just draw attention to the characterization in the first sentence of paragraph 10. The grounds of appeal are in the main criticisms of findings of fact. I do rely on that, although some were referred to as being wrong in law. I mean, it may be that there's not many difference between the formulation that my lord just gave to me and that, but I do draw attention to the fact that they do characterize it as findings of fact.
I don't think that helps us very much, because they also characterize it as findings of law. So, anyway.
All right. Well, can I... the one point which we would make is that irrespective of the expertise or approach to expertise of the board, I've already made this point, but the test, my lord, is already we've already discussed. Can I then look at a concession made in the case advanced page 4397. Paragraph 10. If the Court of Appeal was wrong to reject...
Sorry, what is this document?
This is the respondent's response to our case. It's the respondent's case on our appeal. If the Court of Appeal was wrong to reject the board's assessment of the acquired 10-acre piece on a standalone basis, it would follow that the findings on the value of the acquired 10 acres and its assessment of injurious affection and the use of 16 acres would be set aside, or should be set aside. In our submission, that's an important concession. What I now want to do is make some points about the approach that, the evidence that was presented to the board, and begin by talking a little bit about Mr. Glean. As the board acknowledged, and indeed as the other side acknowledged, Mr. Glean is a civil engineer, and he has no valuation experience or relevant experience of the Anguilla market. In fact, the board withdrew a second report, second valuation report, which the board refers to in paragraph 9 of its decision. That's MS 1891. His method of assessing, Mr. Glean's method of assessing the 10 acres acquired appears to proceed as follows. He says that the 10 acres were part of the forest estate, which extended to the 361 acres, i.e. parcels 100 and 126 together. And the board referred to that as a larger parcel at paragraph 17, that's MS 1894, and paragraph 71, at MS 1913. And that is taken from Mr. Glean's supplemental report, which is at MS 687688, the bold text starting at the foot of MS 687. He considered that the 361 acres which he was looking at provided an opportunity for the development of a tourism project, including a golf course, a beach club, condominiums, flats, hotels, and ancillary facilities. What's important to appreciate is Mr. Glean provided no evidence that this development was financially feasible. In fact, what he said was, the entire family is committed to the Conch Bay development project. He states that in his supplementary report at MS 687. And because a developer produced a financial appraisal in 2011, that's MS 112 in his first report, and Exhibit N at MS 205. He then assessed the value of the acres by reference to three types of evidence: sales of undeveloped coastal land in very close proximity for high-end villas for upmarket tourist development. That's MS 686 in his supplementary report in his selection of comparables. The price asked by vendors for similar purposes, that's MS 692, again in his supplementary report on supporting data, and the amount which stamp duty was calculated when the forest estate was transferred to Conch Bay Development in 2008. That's MS 136. Based on those three categories, he arrived at a price of $1.3 million approximately, which he applied to 361 acres to arrive at a value for the whole parcel, US $472,910,000, and then applied the same price to the 10 acres, which is $13.1 million. It's important to appreciate when we contend that his method was wrong, that at no stage did Mr. Glean expressly refer to Section 18.2. That was a point which the board expressly observed in paragraph 9 of its decision, MS 1981. Nor did he address nor did he address the point that Section 18.2 requires the 10 acres to be valued as if it was a distinct and separate parcel in an open market provided by a hypothetical anonymous seller unconnected with the forest estate. And as I've already indicated, the hypothetical buyer value would have to be assessed by reference to evidence, not simply the aspirations of the actual owner. There was no evidence to support his opinion that each and every acre of the larger parcel was of uniform value, or that on the valuation date, the purchaser would have agreed to pay the sums calculated by reference to the 361 acres. And these points were clearly explained to the Court of Appeal by the Attorney's Counsel, and I'll turn up in due course the oral submissions made. By comparison, the child's evidence made a number of important points. It recognized the requirement to value the 10 acres in accordance with Section 18. That was dealt with in terms of the subject of valuation or basis of value. That's MS 4330. And it's discussed, or at least the provisions are set out in extenso at MS 43778, and reference is also made to the English legislation in Section 5 of the Land Compensation Act. He set out the valuation date as being the 28th of November 2003, which is MS 4330. He also discussed the planning history in the following terms. The planning history is set out at 4349, 4350. Parcel 100 he said, was an integral part of the comprehensive development project comprising 370 acres, the Conch Bay development. The first application for the Conch Bay development was submitted in 2000 for a golf course, marina, hotel, and residential development. The planning department requested an environmental impact assessment, but none was ever submitted, and the application was undetermined at the valuation date. So it didn't have, it couldn't be valued on the basis of the planning permission as of that date. The master plan in 2000 at MS 4351 shows that the proposed development with parcel 100 marked on the western side, together with 10 acres acquired and shaded, and a golf course was proposed. And then it just deals with the significance of the turn in the Anguilla market in 2007, which had the highest level of failed developments in the Caribbean. That's MS 4388. He concluded this valuation of the 10 acres acquired at MS 4385 to 4387. He considered the best and highest use of the acres and concluded that on the valuation date, the Conch Bay project did not meet the financially feasible criteria. And perhaps we could just turn that up. No, I shan't. It's MS 4385. He therefore considered the highest and best use was for residential development by Anguillan residents. And you'll see actually from photographs there's a certain amount of residential development near the airport, subject to the airport-related restrictions which were introduced MS 4386. Mr. Childs identified the sales in the vicinity of the airport between 1999 and 2003 as equating to $48,000 odd. That's MS 4386, and concluded that the appropriate price was roughly $50,000. And then in relation to the cross appeal, which relates to injurious affection, his evidence was on the diminution of the retained land that there was a longer runway. That's MS 4357. He discussed the impact of it at 4388, 4390. There was a modest increase in the runway length, which was insufficient to allow all commercial traffic, because this was not a significant increase in scale to the airport, but it wouldn't therefore significantly affect the existing air traffic disturbance on the property. But the longer runway affected the noise level because it allowed access by larger airplanes, and there was some height restrictions because of the closer proximity to the airways. If I could then...
But just considering, suppose the Conch Bay development was more feasible. I'm not quite sure how, I mean, the Conch Bay development, did that include this 10 acres?
Yes.
But supposing it was financially feasible, where would that have led you to, given that the government still only wanted to acquire the 10 acres?
Yeah, if the, what Section 18.2 requires is that the proximity of the remaining parcel of land isn't to be totally disregarded. The owner of the retained land might be hypothetically envisaged as a potential purchaser of the land taken. The question would then be, would the owner of the retained land be willing to, what would the owner of the retained land be willing to pay in order to affect the land taken in his land holding? So in other words, it would set a figure, perhaps a top figure for what the purchaser might want to sell for, but the real question would be what a seller would want to pay for the land he was acquiring.
The purchaser.
Sorry, excuse me. Forgive me. what the seller would be prepared to sell for, the hypothetical seller would sell for. Have I expressed that wrongly? The point I'm seeking to make is this, is that the proximity of the remainder of the parcel isn't wholly disregarded. It would set a figure, but the question still remains what the hypothetical sale would be for. So it might set a top figure, but it wouldn't set the actual figure. But what's happened here, as you can see, is there is a very large disparity in value between the child's figure and the one for which the estate contended. I mean, it's $18 million, I think, in that region. Yeah. Yeah, so, sorry, just in case I haven't been sufficiently clear. What we would accept is, had the conch development been financially feasible to achieve, it would have given the value of the land acquired a potential enhanced value. There's no question but that. So if the evidence had been there, it would have meant that the value of the land would have been higher. In other words, the point we're making is ultimately the valuation of what's called the highest and best value depends upon what the evidence before the relevant court is.
What notional use does the purchaser put it to? I mean, if you have a, let's imagine this Conch Bay development was given the green light.
Yeah.
But nevertheless, the government said we want to purchase 10 acres so that we can extend the runway. And just suppose that that 10 acres is in one of the corners of the Conch Bay development, upon which no particular villa is going to be built, and it is going to remain largely as scrub, or perhaps a corner of the golf course, which could even be cut off. How is the value to be increased in the way you're describing?
Well, I think the short point I make is it must depend upon the circumstances. It would depend obviously on the parcel of land that you're talking about. You gave one example of one end of the spectrum, so to speak, and it would simply be a factor that would enhance its value. But it's got
no value.
Well, then in which case
to the purchaser as part of a development.
If that's the case, then that would be the evidence that would be the basis upon which it would be valued by the board, or ought to be valued by the board. If it's got no value, then that's...
Well, it's got a value as an extension of the airport, but it's got no value as a part of the development.
No, it doesn't. It may have some additional value, for example, for residential homes or something of that kind, but perhaps your example didn't envisage that. But the point I would make is that it ultimately depends upon the circumstances of every case and the evidence that's adduced in every case. That's why the evidence matters.
Would it only enhance the value in the way you're describing if the rest of the land is owned by the same person who owns the 10 acres? Suppose that those 10 acres have no value of themselves, but that if someone wanted to do the Conch Bay development, they would want to buy up a number of parcels of land owned by different people. Would that also then be a factor, or is it only enhanced if it's the same person who owns all the land that would be used for the development?
I think it has to be the same land, so same owner, in order to justify the level of the enhancement, because that's the relevant.
Well, I'm afraid I don't follow that. But why should it matter which particular person in the Anguillan market happens to think that if they buy this parcel of land, they'll be able to put it to good and profitable use? isn't it merely the fact that there is such a person or are such people that is relevant to determining what the land could be sold for on the open market?
Yes. I'm sorry, my lord, with respect, that must be right. I think the difficulty is in this case is that the figures which were put before the board and they broadly affected the Court of Appeal's approach were figures which were not derived from evidence. I mean, the point is no stronger, that is the point in a nutshell that we're making.
I'm sorry, could you repeat the situation, please?
That the figures that the estate advanced were not based on valuation evidence of any kind. They were simply the aspirations of the estate.
But what was Mr. Childs? I mean, you pointed us to this very detailed discussion by Mr. Childs of the Conch Bay development. But why was he thinking that was relevant, given that, as you showed us, he relied on Section 18.2 and thought that it was a standalone basis?
Well, I think for the very reason that my Lord Sales has been suggesting, it would still be relevant to potential enhancement of the value.
Right.
Yeah. Basically, what you're doing is you're valuing the land by reference to what the open market value might be, and that might well include someone who's prepared to pay more because it's an enhanced value, or on the basis that it's enhanced. Yeah. And as I've already indicated, the position is that Mr. Child's analysis of the factual position was that the development wasn't a runner. That's what it comes to, either in 2003 or afterwards. That's the point that his evidence went to. I wonder whether there might be passages of the board's report, which we might look at now, please. If we turn to the board, please,
Well, sorry, just before we move on from Mr. Childs, and we see at page 4388, he's turning from valuing the land itself, the 10 acres, to compensation for severance and injurious affection. So he accepts that in principle you might get compensation not for the land itself, but for the severance effect in relation to other land, and also for injurious affection from the project in relation to that other land.
Yes.
And in relation to severance, isn't this quite significant that he says, in his view, there is no severance effect by taking out the 10 acres from the rest of the project? He's saying it doesn't affect the value of the rest of the project.
yes.
And therefore, severance is put to one side by Mr. Childs on his evidence, and he then goes into injurious affection.
Precisely, yes.
I
Yes.
just wanted to check that I had understood the way his report worked. So
Yes.
that is concerned.
My lord is correct. If I could just turn quickly to the board decision.
Sorry, just before we move on from that, am I right in thinking that Mr. Glean did not give evidence of any severance effect?
That appears to be the position, yes.
Right.
I mean, what he did was essentially just attribute a value which he took arithmetically from the basis of the overall development value, if I can describe it, of the land. He simply applied the same figure. If I could ask you to turn out page 1891.
1891.
Please. You'll see that
Is this the board's decision?
this is the board's decision, yes. He refers at paragraph 9, or the board comments that it's noticeable that Mr. Glean did not quote the Land Acquisition Act at the stage of doing his reports. That, with respect, in our submission is an important observation. Then if you turn through to 1894,
Do we have the letter of instruction to Mr. Glean?
I'm sure we do. If you just give me a moment.
Page 87, I think.
Sorry, Mr. Rao, I missed the page.
Page 87, my lord, I think.
Can you just give me a moment to pick it up?
Well, don't worry. It was just
Well,
if it's at page. Yes, I see. That's fine. Let's go back to the board's decision.
yeah, it doesn't really tell us very much. Then, if you could, I was going to ask you to go to 1894 and paragraph 17, where you can see that the land is derived from something called the Dictionary of Real Estate Appraisal. What's the larger parcel? They rely on that definition, which is and then if you could turn up 1912, paragraph 69 observes that the board was faced with two very divergent claims with two distinct methods of assessment, and they expressly approach it by reference to section 18, that's paragraph 70. And then they give the crux of the claimant's case at 1913, paragraph 71. In the case of partial taking, the value of the larger parcel must be ascertained to determine the unit value. And then you can see the conclusion that he reaches. Then, if I could ask you to read a passage about the highest and best use, which is the approach the board took to the valuation evidence. That's at page 1914, paragraph 76 to 82. You'll see it summarizes the position advanced by the claimants. The 10 acres was part of coastal lands. The tribunal had no reliable evidence to conclude on a different highest and best basis. They were asked to make it on the evidence as a whole after due consideration of the relevant valuation standards and case laws. The highest and best was the integrated use to which the family had dedicated as part of the larger tourist resort development. The board responded, it stretches common sense and the facts to hold as the landlord urges that the best use required was that of coastal land. The land located in front of the airport was some distance from the coast. Accepts the expert testimony of 10 acres on a standalone basis. And then turning to 1915, when you value in 10 acres, you're just valuing 10 acres. He's not valuing 100, he says. It's a fundamental issue, says Mr. Childs. The law, the Act is very, very clear on what is being valued and what the instructions are. On further cross-examination, he said whether it turns down to is whether the 10 acres is an independent marketable interest. And then the point which was made by Lord Briggs, or which I referred to in the context of Lord Briggs, was how do you deal with the valuation of a strip? That's dealt with at 79.
But it's very curious as to how you fit that into the statutory test that you've been urging us to adopt. And the strip of land has no market value as such. One nevertheless assesses it by reference to the proportion of the whole which it represents.
Well, what that indicates, two things. One is that you look at the overall position, the total period of that, in very exceptional circumstances, and it's precisely because it must have more than zero value that you pragmatically do the best you can. I mean, remember, we're here talking at 79 of a narrow strip, which actually has no value. So the question then becomes, well, could it be acquired for free on the basis it's zero value, or should some value be attributed to it, which the compulsory purchase authority has to pay? So, I mean, it may fit uneasily within the framework, but one can see the pragmatic justification for it, because otherwise you'd end up with land acquired for no value at all.
Well, depending on whether the strip isolated the retained land from access to a public highway, for example,
Yes.
There might be quite a lot payable by way of severance.
Yes.
Or injurious affection, depending upon what the acquirer intended to do on the strip.
Yes.
So that it might well be that the real loss caused to the landowner who's having his strip taken away would not in fact lie in the value of the strip,
Yeah.
but in the consequences which would be reflected by another part of the compensation scheme.
My Lord, with respect
I take it that although the Act in this case makes no reference to severance or injurious affection, it's common ground that they are part of what there can be compensation for.
it was accepted before.
It was, I think, yes.
Yes.
I'm not sure severance was particularly discussed, but certainly injurious affection was.
That's right.
Yeah.
But also with the strip point, that if the owner, for example, is growing a crop on the whole parcel, right down to the edge of the motorway, and every year it's planted out with potatoes or wheat, then the land has a value to him because he gets money for the crop. But if you wanted to sell a 10-metre strip of that, nobody's going to buy that to farm because there's no access to it. You wouldn't farm by yourself just 800 yards of wheat or whatever. So it has no value for itself as an agricultural holding, but obviously if it's acquired, then there's that much less wheat or potatoes for the person who's previously farmed it. So one can see that it had a value to that person,
Yes.
although no one would have bought that strip. But as you say, it's a pragmatic response to the fact that you have to reflect the value of what you've taken away from the person.
Yes, doing the best you can. And sometimes, because at the end of the day, the whole valuation exercise is a fact conclusion based on evidence, doing the best you can with the material you have. I mean, it's sorry? Yeah. It's not, I mean,
Would, in an ordinary case where the strip, let's say, lay on the edge of one person's farmland, bounded by another farm, then the highest price would be that which would be paid by the farmer next door, who would indeed be able to add it to what he was farming. So there wouldn't be a problem by applying a conventional valuation technique. But where the bit next door was a motorway, it might be an altogether different problem.
well, at the end of the day, I think most, if I may say so, I think most of the examples that we're dealing with simply illustrate that one has to look at the factual position quite carefully.
Yes.
And and it is essentially a factual question resolved by evidence, but beginning, as my Lord Sales pointed out, by getting one's centre stage, the statutory framework. What I next wanted to look at, having dealt with the strip issue in 79, was what the position was as far as the board was concerned about value. This is paragraph 80, 1916, MS 1916. No planning permission was granted, had been granted. Application was pending. The refusal of permission in 2011 should be taken into account, and they don't agree with that submission. I mean, can I just deal with that quickly? That's actually, in a way, the cross appeal, and that's about the permission in 2011 in respect of 4 dwelling houses. And the short point there is that the board rejected, and this was a submission made to the Court of Appeal, they rejected the submission that this was a no-build conclusion, that permission had been refused on the basis it was no build. It was refused on the basis that the roof... pitched roof, forgive me. A pitched roof interfered with height restrictions and therefore had to be refused, those 4. And that, leaving aside any question about concurrent findings of fact, that was the actual factual basis upon which the claim made was for no build in 2011 was based. And that was, with respect, based on Mr. Glean erroneously understanding what the refusal in 2011 was for.
Since you brought that up, may I ask you please just to give us the page reference where that becomes, from which that's apparent? That the refusal was based on the fact that pitch roof led to the height limit being exceeded.
Can you just give me a minute? I think you'll find it in the best references are in our reply to their cross appeal, which I think is, forgive me, you'll find our reply is at MS 4298, and we set out the references at paragraph 5, if you have that. That's 4300. Do you have that? MS 4300?
4300, yeah.
I mean, it sets out at 4 what Mr. Childs explains what the impact of the on retained land was, which is worth reminding yourselves of. That's A, B, C, and D. But Mr. Glean relies upon planning permission which was at 47236.
Was the question, where's the actual letter from the council or from the authority? Yeah. That's at 2725.
Yeah, 27, sorry, it is. It's where we say paragraph 5, we rely on refusing the planning permission. So it's the decision refusing the planning permission which matters.
But I think the issue is what's the basis for the second reason given in the decision letter at page 2725.
Yeah.
You're submitting it's based on the fact it had a pitched roof, which led to the height limit being exceeded.
Yes.
But what is said against you is that this talks about an area of total restriction for all build development.
Well, whatever the language of the decision itself, one has to look at the restrictions in place at the relevant time. They were a height restriction.
Well, where do we get the height restriction from?
Can you give me a minute?
You see, it doesn't say we refuse this because you've got pitched roofs on your 2-storey buildings.
That I accept. Right. Yes, I do accept that. But that there is evidence of the height restriction. It's dealt with in Mr. Childs'.
I don't want to take you out of your course. I was trying to understand the basis of your submission. If you're going to come back to it, then
I can come back to it. Can I invite my we have put the references in. In fact, actually,
But I'm not sure you have. I mean, as I understood your case, you're saying that there was some pre-existing planning control in relation to this site, which included a height restriction at 2 stories.
yes.
And although not the language used at page 2725, we should interpret that as being permission refused because your development is not in conformity with the plan.
Yes.
I don't think you've ever given us the reference to the plan. I might be wrong, but where is the planning policy? That would be helpful. We don't need the reference now, but it would be useful to know that, because that might then assist us to interpret what the letter at page 2725 meant.
Well, can you just give me one moment? It's actually given here. Well, these points were specifically made in oral submission, but I don't think the reference...
I don't think we're asking you about oral submissions, Mr. Clayton. We're asking for the reference in the bundle.
No, I understand that.
To the plan.
Yeah, so the transition zones appear at 4366 and 4367, and actually they're discussed in the report.
So, right. I don't think this is the plan. I think this is an excerpt from Mr. Child's report, isn't it?
Yes, it is. You're asking for the decision itself.
No, I was asking for the plan. As I understand your case, to reiterate, you're saying that there was some pre-existing planning policy applicable in relation to the relevant land, which limited the height of buildings. We haven't seen, so just to make the point, we haven't seen that plan. I was asking for assistance. Where can we see that plan?
Well, it's neither a plan nor a policy. It's a requirement not to infringe the transition zone, which is why we took that. That is the requirement, not to interfere.
Where does that requirement come from?
Can you give me a moment?
Yeah, I'm not inviting you to take up time on it now, because it may be
I'll
that
come back to that.
you can collect your thoughts over the short adjournment, but it would be helpful to know what the planning framework was against which that decision was taken.
I understand.
Yeah, I mean, this also goes to the point that the injurious affection claim, the award was made on the basis that the injurious effect was a limitation on building of above 2 stories, whereas the estate's claim was the injurious affection should have been based on no building to be allowed. So where this 2-story limit comes from, I think, is what we're...
No, I understand. We can come back to you after the short adjournment, I think. What I wanted to take you to was the submissions which we are advancing were really the same submissions as were advanced to the Court of Appeal. You can see that not simply from the skeleton submissions, which are at MS 232 to 2232 to 2255, and the supplementary skeleton, which I've already taken you to, which is 2360 to 2363. But it's also, with respect, plain from the oral submissions advanced to the Court of Appeal. You'll remember.
Before we bury ourselves in them, unless it's being taken against you that you're raising some new point for the first time now, why does that matter? And why is it material to delve into how the way was put to the court?
Well, no, it's quite short, but it just deals with, I'm just indicating that the case that we're advancing before the board is really just the same as the case advanced before the Court of Appeal. I mean, it's really no more than that. Okay. But I suppose the value of it, or an additional value, is that it's explained really very carefully and clearly, and it's therefore difficult to see how the Court of Appeal arrived at a different...
Well, it did.
But it did.
And even if it hadn't been explained all that clearly, if the Court of Appeal went wrong, they went wrong.
Yes. All right. Well, I accept that. Well, what I'm going to do then, I think, is I'll just take you to the references in the light of the various observations that have been made.
But sorry, why?
Well, when I say take you, I'm just going to give you the numbering. Okay? I'm not going to do more than that. But it is of some assistance, and I just ask you to look at MS 2449, line 15, to MS 2451, line 24. That deals with the the focus on section 18. Then the comments on the weight attached to international valuation standards, that was explained by counsel at 2451, and then specifically going to 2454. They don't provide, he makes the point that they don't provide rules, but the guidance, but the statute does, and you pick that up from 2454, line 4 through to line 20, and then at the submission that there was no evidence before the board that Forest Estate had value as part of intended resort. That's at 2455, line 7 to 10. And the last point, which I was making before, the reference to the reference to the decision letter, again appears there.
2455.
We've prepared a note, really, a speaking note on the authorities, which I hope speeds the process. Can I hand that up?
Do you have it electronically? I haven't used paper for about 2 years. I haven't forgotten how to if I have to, Mr.
We'll obviously send it to the...
I would be grateful.
Thank you. I apologize. I'm afraid counsel is behind the court as very these sorts of things. But can I pass this to someone?
Yes, I mean, by all means do.
Mr. Rose got it.
Not yet, my lord. I don't think so.
Yeah, I'll take one.
I'm sure you'll be able to get us an electronic copy by the end of the short adjournment. If you send it to registry, they will simply pass it round.
Yes, certainly.
And while we're talking about notes and so on, I got a report together that my note has now made it. So.
It's made it.
Yeah.
We were apparently assured when it was filed that it would be passed to the board. So
It usually is. Home and
for some reason it went wrong, but
Yeah, got it.
If you have the note, I'm sorry, we will obviously get you the electronic note. I apologize. Well, paragraphs 1 to 3 set out submissions I've already made. Turning the page to paragraphs 5 onwards, Mr. Glean, the board found that the evaluation methodology that Mr. Glean favoured would apply appropriately to a strip of land. We submit that there's no evidence of planning permission at the 2003 valuation date. At 2011, for reasons they've already gone with, was irrelevant. And we make the point about evidence again. And what I'm going to do is the authorities in this note, because in fact the passages relied on are all very short. And so we've set out the relevant passages in the judgments in this note, although obviously you may want to read the judgment in due course. The first case we point to is a well-known one, Southeastern Railway case, where the Court of Appeal upheld the decision it was wrong in law to assess market value by carrying out an overall before and after valuation. The claimant owned property at the south end of the Strand, further property to the rear near Craven Street. First was acquired to widen the Strand. The consequence was Craven Street, now fronted onto the Strand, had substantially increased its value. The acquiring authority contended the compensation payable for the acquisition of the Strand property should be calculated as taken as the difference between the two properties taken together. Obviously, that would reduce its value. That was rejected by Mr. Justice Eve in the Court of Appeal. They held compensation payable was the open market value of the Strand property.
Have I correctly understood this decision as being one where the effect of the purchase and its change in use was to increase the vendor's, the value of the remaining property held by the vendor?
Yes.
Or the person whose land had been compulsorily acquired. So it is a rather unusual case.
I'm not saying it's not an unusual. These are the cases, if I may say so, subject to the board's decision in due course. The cases which deal with this are not entirely satisfactory because they say the principles are well established, but the context in which the cases get, the points get made is not entirely straightforward. So I entirely accept my Lord's point that it is an unusual set of facts. But what Mr. Justice Eve and the Court of Appeal made clear, and you'll pick this up at page 3 of the note, was that you have to look at the value of the land acquired only. You don't look at a composite.
Until you get to what in your note is a, quotes, further claim for compensation distinct from the market value, or when you're looking at Botheringham and Chiltern, reduction due to severance.
Yes.
Yes.
So that effectively you're taking it in parts. You're dealing first with the value of the land acquired, and then secondly the compensation due to the retained land, which is a separate category. But what you don't do is lump the value of the retained land, including the acquired land, at the first stage.
But how does the before and after method work then? All right, so you look at the whole parcel with the acquired land and you say the value of that was £1 million, say, and then you look at the value of the land without that part and you say it's worth only £750,000. So then the difference is the value of the acquired land, or
well, it may also include the affection.
It does, with respect. That's right. The point about the before and after test, it really doesn't help in the context of this case, this particular concept, because before and after is used as effectively a reality check to cross-check the compensation both for the land acquired and for the retained land. Yes. It's for both.
Right, but so how does it work when you're using before and after land? What are the different steps that you use to get? I see. So when you're using before and after land, you don't end up really valuing the acquired land at all.
Well, you don't end up valuing solely the acquired land. That's the important point. The before and after approach is intended. You do your calculation in the first instance. What is the compensation due for the acquired land? What is the compensation due in respect of the retained land? And you do that valuation exercise, and then you can cross-check it by just doing a before and after, and the two should be roughly the same. That's the point of the exercise. But the one thing you can't do is use the before and after test to look at compensation solely in respect of the acquired land.
And nor can you use it to say that, well, actually, you're better off as a result of my having acquired the land.
Yeah, exactly, which is, in fact, was the very holding, in effect.
That was the southeastern argument.
Yeah, exactly.
Yeah.
That's exactly right.
I suppose to take an extreme example, suppose you have a plot of land which is just big enough for the building of a 65,000-seat football stadium for which you had planning permission, and the government proposes to take half of it. Neither of those halves would be worth a row of beans compared to a football stadium. That wouldn't affect what you get paid for the compulsory purchase of the half, but it would sure affect what you get by way of compensation for severance in relation to your retention of the other half.
Precisely.
Yes.
Precisely. And it's quite important to bear in mind, I mean, unfortunately, the way in which before and after is used at various stages in the case isn't necessarily particularly helpful, but it's important to remember that the before and after approach is both in respect, well, looking at the total compensation due, which includes both the land acquired and the compensation for the land.
But is the possibility of claiming for severance and other injurious affection, could that be by someone who owns a different parcel of land? To take my Lord Briggs's example, suppose that there were two plots of land that you would need to combine to build the football stadium, owned by different people, and the government wants to acquire half of the plot of land. To ascertain that value, the owner is entitled to say, I would have got a lot more, well, are they entitled to say, I would have got a lot more money if I'd been able to sell it jointly with my my neighbour? And can the neighbour then say, well, actually, although you haven't acquired any of my land, the value of my land has now plummeted because I thought I was going to sell it as to be half a football stadium, but now I can't.
Well, is the example you give based on there being separate landowners?
Yes.
And the second landowner is one who has had no land,
Exactly.
simply affected by the outcome of the compulsory purchase.
Exactly.
Well, that's, in our submission, that's a very different set of circumstances, because you're compensating for the compulsory purchase for the person whose land is being acquired.
Yeah, so I'm just wondering whether under the Anguilla Act or under the English legislation even, there is the potential for someone whose land is not compulsorily acquired, but who nonetheless suffers a diminution in the value of their land to make a claim, or whether compensation is only ever paid to the owner of the compulsorily acquired land.
Right, well, sorry, can you just give me a moment? Well, can I just deal with it? It's like a complicated answer. In respect of Anguilla, the position is different from the English one because there are no express provisions in respect of severance. So it was, but everyone proceeded on the basis the British principles applied. So that's the first answer. In respect of the UK, or at least England and Wales, I confine myself to that. The position is that a separate owner wouldn't be entitled to compensation as a matter of under the compulsory purchase legislation, but he might seek compensation on the basis his property has been blighted,
Yeah.
which is a separate regime.
Yeah. It wouldn't be severance. I mean, whether or not it's severance, I suppose, depends upon whether the person who is having land taken away is actually the owner of the neighbouring land that's being retained.
Precisely, my lord. That was the point.
That's why the first issue was so important in this case, about whether the estate's land was just the 110 acres or the much larger plot.
Precisely. With respect, we agree.
Yeah.
But I mean, also, just to emphasise a point made before, there is no case about severance, a severance effect on the balance of Parcel 100 from taking the 10 acres out of that.
No.
So there was no evidence from Mr. Glean that there was a severance effect. Mr. Charles said positively there was none. I was just looking at the list of issues put forward by the claimants to the board. So this is page 1892 to 1893. And what, in the current context, is significant there is no separate issue put forward of a severance effect in relation to taking the 10 acres out of plot 100. There was an issue, issue M, in relation to compensation for severance of the 26 acres from the whole parcel to be assessed.
Yes. Well, with respect, we would...
So in other words, it's not surprising the board didn't deal separately with severance in relation to the 10 acres. No case was being presented to it that required it to do so.
No, and in fact, I hope I'll be figuring so the case that was presented to the board was by Mr. Glees was not an entirely orthodox valuation for the purposes of compulsory purchase. It was a...
But Mr. Glean has focused on, if you like, the first step in the inquiry, looking at the value of the 10 acres itself.
Yes.
And that's what his methodology is directed to.
Yes.
In some circumstances, one can see that the before and after effect might take into account both the value of the land being acquired and a severance effect on other land. But in this case, there was no case being put forward of a distinct severance effect from the 10 acres being removed from Parcel 100.
That is correct. And at the risk of, it's obviously rather an important point for which perhaps we ought to have made more clear than we have. But that is, with respect, entirely right.
Yes, thank you.
Well, I've been asked to take you to deal with a point made by Lady Rose. If you could turn to MS 1927. This deals with the point, sorry. This actually just really makes clear a point I've already said, is that compensation for the retained land requires the retained land to be under the same ownership. And that was the distinction between Parcel 100 and 136. And that's made clear at 1927, 113 and 114.
That seems to be in part of the problem, that they were in separate ownership.
Yeah, I think the position is that separate in the sense that I think 136 was owned by by members of the Lane family in addition to the Dame, the owner of 100. So it was owned by the Lane family, but it wasn't identical ownership. So it wasn't the same ownership. And that's what the...
and there was also a public right-of-way between the two.
And that's also true.
Yeah.
To go back to the note, if I may, the next English authority of note is a slightly complicated Court of Appeal authority. That's the Hover in Graham's. Yes. And there, the question was whether the value of the backland, this is paragraph 11, the land acquired, and the front land were taken together. And that was rejected by the Court of Appeal. It held, assessing the compensation of the backland, that it was necessary to find the value of the backland, the land acquired, and separately to consider whether there were any reduction in the front land. That's entirely in line with the submissions that we've made. And the relevant passages which we draw attention to is they answer 13 to a backland, and they say the language of the statute compels an assumption of separate sales. Now, there is a slight complication in the facts of Hovering and Graham, which was that the different properties were owned by different local authorities, but that, with respect, doesn't affect the principle involved.
Could I just ask you about the basis for the concession that the Anguilla Act makes provision for compensation for severance and other forms of injurious affection? Is it because if it didn't, it might be found to be unconstitutional?
I
can see your colleague nodding.
Yes. I'm sorry.
We might have Lake 3, namely a further attack on the Constitution.
One can't help thinking that there would be some complaint about, because I think the whole thrust of the attorney's case at every stage has been that the Anguilla legislation reflects the English law. So there would be obviously incongruities and therefore problems constitutionally had there been heads of damage or compensation recoverable in England which were not translated into heads of recovery. So I think that's the basis for the concession.
Was that set out in any of the written submissions below?
It's not that we've spotted, but I mean, of course, the one case on the constitutionality of this act was brought by these claimants. So I think
could I
once
ask you
bitten,
please
twice shy.
I beg your pardon. Could I ask you please to be clear with us? How far does your concession go?
Our concession goes this far, that the approach that we invited the board to take reflected settled principles in English law.
Including the effect of Section 7 of the Compulsory Purchase Act of 1965 as understood in the authorities?
Yes. Yeah. That which deals with retained land. I mean, I think that's the basis, or the statutory basis for injurious affection.
Well, it appears to be the basis for the decision in Hoveringham.
Yes. Can I move on in our note to deal with the Abbey Homesteads Group case? Now, this is a decision of a lands tribunal, but the two Court of Appeal authorities to which I've already referred were applied by the lands tribunal, and the easiest way of tackling the lands tribunal judgment, which the layout isn't entirely straightforward, is we set it out in paragraphs 14, and you can work out essentially what's happened, and expressly what is rejected is that you look at the retained land for the purposes of computing compensation to the land acquired. I mean, I suppose it's maybe rather an obvious point that it hasn't struck us, but it's slightly odd to think that you look at the value of the land retained to value the land you acquired when you're compensating for the land retained as injurious affection.
Yes, although of course the Anguilla Act doesn't have anything about that in it.
No,
it's understandable how the English courts, looking at a land compensation statutory scheme which provides expressly and separately for compensation for the land acquired on the one hand, and compensation for severance and injurious affection to the land retained on the other, to say, well, that's two processes, and they mustn't be jumbled up. Here we have an act that doesn't say anything about injurious affection or severance.
Well,
and one possible conclusion is you have to somehow squeeze it into the primary basis of compensation.
yes. Well, I think.
I don't know if that's going to be submitted, but this is just sort of idle speculation by me, derived from inability to avoid the fact that these two acts are rather differently worded.
They are differently worded, and we accept that. But I think it was my Lord Briggs who also pointed out the desire to avoid a constitutional challenge.
Yes.
And certainly, I'll just finish this and then I'll take it.
Because no doubt the purpose is to avoid landowners suffering in their pocket from the compulsory acquisition of part of their land and the use which it's then to be put.
Yes. Sorry. I see. Thank you. Well, the attorney has reminded me. I'm not sure whether you have the constitutional decision, but the constitutional decision emphasised the need for adequate compensation. Yeah. And obviously that what was seen as adequate was that which reflected the settled English approach.
One's bound to have some sympathy for a valuer who's presented with an act that only contains.
Sorry?
One has some sympathy with a valuer who's presented with an act that only contains provision for compensation for the land taken away, to work out how you get fair and full compensation in that context.
Well, one understands that, but yes, one has some sympathy.
Yeah.
Can I just clarify?
Sorry, can I just go back again? I mean, leaving aside the issue of severance entirely for a moment, or injurious affection, if there were a planning approval to build a series of high-end properties on a piece of land, and the government comes along and acquires a part of it because it wants to expand a road, for example, and in that way deprives the landowner of that part of its land upon which one or two properties would have been built. It may well be that in the open market nobody would have had any interest in building those properties, and consequently the land on a notional open market sale would not have reflected that approval.
Yes.
Now, there may be affection to the remaining land. There may be a severance loss.
Yes.
But would the severance loss include the loss of the loss of profit that the landowner would have made on the properties on the actual land acquired?
Can you just give us? Yeah, I think that must be right. I mean, I think.
Sorry, what must be right?
Sorry, that the profit.
The adequate compensation.
The adequate compensation in respect of the land acquired would include the loss of profit in the.
Well, the loss of value to the landowner, but not to the person acquiring the land.
Yes.
Of the high-end properties on that particular acquired land.
Yes, I think that must be right.
I mean, severance, therefore, may be a loss which is strictly wider than just a loss attributable to the diminution in value of the retained land.
Yeah, well, yes, and I mean the trouble we're putting all sorts of.
Well, it's important because I mean, as I understand it, this partly underpins Mr. Rowe's case, because he says the tribunal ought properly to take into account, on the assumption he's got planning permission for this conch-end development, I want the tribunal to take into account the increased value of that land you're acquiring in my hands.
Well,
because that is the subject of the development.
May I explain our approach to that, which is, in principle, as we've just discussed, they may be entitled to compensation, but in the end, it's a matter of valuation evidence.
Well, it may be the conch-end development was a dead letter.
Yeah.
But we're just trying to identify the relevant principles.
No, I understand that. I'm sorry.
I understand that you now to be conceding that despite what you submitted to us earlier, as I understood your submissions earlier, if the value of the acquired land the actual acquired land, is greater in the hands of the original landowner than it would be in the hands of anybody else in the open market, that is nevertheless something for which the landowner can secure compensation.
Severance.
Well, perhaps one calls it severance, but it is not just the impact on the retained land, it's the loss of the ability of the landowner to exploit the acquired land.
That's true, but can I just make two quick answers in response? One is that it may be that it is the better way of describing it is that it's debt compensation to the retained land.
Well, you can call it what you like, but it will include the loss of the additional value of the acquired land in the hands of the original landowner. Because he's lost that value, and it's not a value that would be reflected in the open market
Provided it's a value that the
valuation of the acquired land.
Forgive me, sorry. If provided it's a value that the hypothetical seller, and it is the hypothetical seller, not the actual seller, one must to remind oneself of, that the Act requires us to look at. And that's also the position under the English system as well. It's the hypothetical seller.
The hypothetical buyer.
Sorry, hypothetical, I'm so sorry.
Well, take my football stadium example.
Yeah.
Neither the buyer of the half of the relevant site, which was just big enough for the football stadium, nor the holder of the retained other half could build a football stadium. So that the valuation of the land being acquired would not include its what I might call football stadium development value.
Yeah.
Equally, looking at it as in terms of the value of the retained land, nor would the ability to build the whole of the football stadium be part of the development value of the retained land. But there would be no doubt that the severance of an original single plot into two would cause the owner to lose the whole of the football stadium development value.
Yes.
And what I think, Lord Kitchen, I'm putting to you is that probably would fall within severance, so that applied to this case, the severance off of the 10 acres near the airport from land which otherwise stretched all the way to the beach might mean that a development which was viable for the whole of the plot, including the 10 acres, wouldn't be viable at any rate for the 10 acres once sold off. It wouldn't form part of what a buyer would pay for that 10 acres, but it would form part of what the owner had lost. Is that right? Yeah.
Yes, with respect, yes.
Okay.
But as you say, it would require evidence.
It would require evidence.
That would be your response, I
Yeah. And can I just step back a step, because the question about compensation, how it was dealt with, and the implications of the constitutional decision was expressly dealt with in Mr. Gleave's evidence, Charles' evidence, Charles' evidence. Could you just turn up pages 4380? If you have that. Commentary on valuation for compulsory acquisition, if you have that bit. The Land Acquisition Act does not... Sorry, do you have that? Yeah. The Land Acquisition Act does not address heads of compensation, severance, etc., and provides only limited guidance to valuers beyond the Section 18 itself. While the valuation for compensation must be guided primarily by this Act, established valuation practice from elsewhere in the Caribbean and in the UK would help establish the general principles of valuation for compulsory purchase. And then if you could please turn to page 4381, the next page. The section under severance and injurious affection. At 4381, just the third line.
Yeah.
So that the impact of the constitutional case was expressly addressed by Mr. Childs. and his understanding and the basis of his concessions expressly set out. Then, in fact, can I go back to the note now for a moment? That we deal next with the Cayman case, which is relevant because my lords will have in mind that various other Caribbean countries, we expressly refer to this in our case, have the same regime as Anguilla, and therefore, yeah. They deal with, but you can see the position taken by the Grand Court.
Sorry, just before we drift away from the previous late decision, I think it would be useful if we could be provided with a copy of it, just so we've got it.
Certainly.
I think you have.
Oh,
Is that the Constitution or what they call
Yeah.
the Constitution? Yeah. That's it.
Oh, I'm sorry. It's
think you have got
actually
it
in
on
tab 13. Sorry, it's in page MS 4653.
thank you.
Oh, and I'm reminded that in the appeal itself, the Court of Appeals set out the deletions made as a result of the case at paragraph 50 at 4675.
Thank you.
And essentially, the Cayman case looks at the legislation which is contained in the schedule. It's at 17A. And then the first issue was whether the road assessment, this is turning the page 6, was whether the road assessment could be erred in valuing the land acquired on a standalone basis. And then C, the court held there can be no doubt that the task set by the statute is to assess the market value as defined, and further, when deciding the value, the court must ignore for the purposes the land retained. So the position in the Cayman is the same.
Does the Cayman legislation provide for compensation for severance and injurious effect?
We have the Cayman legislation. I'll come back to that if I may.
Yes, by all means do, but in order to get a
Sure.
picture of its comparability,
Sure.
I think one needs to understand that aspect.
No, I understand, but just because I want to take you to a slightly different area, I'll come back to that if I may. We deal in the note with cases that are relied on by the Court of Appeal, but I think it may be of assistance, since my lords raised it, to ask you to go to page 8 of the note, which deals with the Ramac Holdings case.
Oh, good.
Yes.
Now, this case, in our submission, states the correct position. It was cited by the attorney in the skeleton argument, not referred to in the judgment. 1.9 acres forming part of a 61-acre industrial site was purchased. Tribunal rejected the contention that the land acquired should be valued as part of the industrial state holding. This is a 2114. In our judgment, the effect of Rule 2 of the Section 5 of the Land Compensation Act is clear. The reference land must be valued as if it alone was being sold on the open market by a willing seller. This is a hypothetical basis because the seller may be anything but willing, particularly if the reference forms part of other land retained by it. Insofar as the claimant suffers a loss because of the diminution of the value of the retained land, this will form a claim for compensation for severance and injurious affection. It does not justify adopting an artificial approach in valuing the reference land as if it was formed as part of a larger whole. And the Ramac case serves to underline really at least two points. One is that that it's important to bear in mind the distinction between compensation for the acquisition of the land itself and a compensation for the retained land. And that, with respect, is a distinction which doesn't figure very prominently in the evidence of Mr. Gleaves, and indeed, as my Lord Sells pointed out, in the list of issues, didn't figure very prominently either. Then, if I could, sorry, just go back, because since my Lords had asked about the
Well, sorry, I mean, since you raised it, an aspect of the impact on the retained land was raised, i.e. injurious affection. That was very clearly identified as an issue.
Yes. No, that, yes, I accept that, but then, I'm sorry, on my submissions remain in respect to the same effect. It's always a question of evidence, and the evidence advanced by Mr. Gleaves simply didn't get his case off the ground.
Yes, thank you.
What I wanted to do is if I could ask you to turn to page 6 of our note. And this is actually underlined.
Is there anywhere in the case law which formulates what is actually meant by the term severance? What actual kind of loss or effect is encompassed in the use of that term? Again, it would be useful if you could point us to somewhere in a textbook or in a case which describes what is being compensated for when there's a compensation payment for severance.
Well, the answer is there is some case law, but we haven't brought it with us, but we can provide the board.
I would find it useful to see some description of what severance means and what kinds of situations it's dealing with.
There is a description in the valuation methodology exhibited in Mr. Charles' report at 4381, third paragraph down.
If it helps, my Lord, and I'll deal with this in my submissions, of course, in a proper place, but our note exhibits the Law Commission's work on this subject, which helpfully, as they always do, sets out the existing law in quite some detail and quite some clarity. That's page 134 of our note.
Is that of your new note?
That's our note from last week. Yeah.
Certainly.
Hesitate to concede that new.
The 3rd of May.
The 3rd of May note.
Page 134.
Page 134.
I'm sorry, Mo?
134.
Page 134
Thank you.
of the PDF. Yeah.
Certainly the Compulsory Purchase Act talks about severance or otherwise injuriously affecting. So that would rather suggest it's included within injurious affection. Anyway,
But I think the particular point which is concerning at least some of us is the concept that severance may not, and injurious affection, particularly severance, may not be limited to the consequences as the owner of the retained land.
Well, yes, that's what I was...
That's the real interesting point, I think, for present purposes.
Yes, because that description by Mr. Childs does seem to think it's something to do with the value of the retained land rather than the, as my Lord Kitchen was positing, a potential enhancement of the value of the lost.
It certainly looks as if injurious affection does. I'm not sure severance may be slightly wider defined. Yeah. But there's bound to be some authority on it, Mr. Clayton.
There is, and I'm afraid I can't answer that question now. What I wanted to do is just, at this point, briefly turn to some of the cases which the Court of Appeal did rely on in taking a different course that it did. If you could pick it up from page 6 of the note, first of all, there's the New Zealand Land Tribunal case of Hamilton. It's important to appreciate that the difference in legislation is significant. Section 60 of the New Zealand Act did not contain an equivalent to Section 18.2 or Section 5.2 of the Land Compensation Act. It instead provided a composite entitlement, meaning for compensation for that acquisition taking injurious effect, for that acquisition taking injurious affection or damage. So the question of a standalone value didn't, strictly speaking, arise. It was a composite figure.
But aren't we saying that actually the impact of the Constitution on Section 18.2 of the Anguilla Act is actually to turn it into a composite?
No, we're not saying that, with respect, my lady. What we're saying is the effect of the Constitution was that adequate compensation embraced severance and injurious affection. We're not saying it turns it, but one has to. I mean, if categories matter, and our point about 18.2 is 18.2 focuses on land acquired. So, and so that we're clear, I'm not saying it doesn't mean you can't get any more, but one has to, taxonomy matters, is really, I suppose, the point I'm making. We also point out that the Lands Tribunal, this is paragraph 19, didn't need to decide whether before and after was lawful because it was agreed by the parties and not an issue. And equally, if we turn over the page to the New South Wales Court of Appeal case, the Road and Traffic Authority, that too did not, paragraph 20, did not concern whether the before and after method was lawful in the light of statutory language analogous to Section 18.2, nor did it consider any of the United Kingdom authorities which we have already discussed. The claim, in fact, contained injurious affection and did not concern the value taken. And the paragraph 22, the valuation undertaken focused solely on the claimant's retained land to determine compensation for injurious affection to the retained land. And they say a slightly different approach needed to be taken in respect of the resumed land separately from the injurious affectation. But with respect, that formulation and that statutory regime doesn't make it authority for the proposition that before and after is a relevant question to ask in respect of acquired land. That's the point. I'm conscious that the cases that I go on to look at include some of the matters raised in my friend's note of the 3rd of May. I wonder whether in the light of that it might be convenient to stop at this point and
we'll do what we can over the short agenda.
Thank you very much.
Yes, thank you very much.
720 pages. 720 pages.
Yes, it's rather a long note, I gather, but there we are. If we include all the
The note itself is only 10 pages, my lord.
Yes, well,
Most of the bulk comes from the fact that I copied the whole of the Law Commission report, only a few pages of which are relevant. So,
regardless how much of the note we have by then absorbed, we'll resume at 2 o'clock.